families, creating a lifetime of memories. Sadly, some families are denied these important moments due to the sad practice of alienation. These are families divided.
Hello, everyone, and welcome to our new year of Families Divided TV. I'm Elaine Cobb. I'm founder and president of Family Access Fighting for Children's Rights. I'm also the founder, host, and executive producer of Families Divided TV. We are so excited about this upcoming year and all that we'll be bringing to you to help those of you who are alienated family members, as well as those of you who are professionals who work in the field of alienation. There's so much more that needs to be brought to the forefront, and we're hoping to at least touch part of what needs to be brought out and give you as much knowledge, information, support, and encouragement as we possibly can. We hope you'll be a part of us. If you haven't subscribed to our YouTube channel, please do so. That's very important now. Everything is going to be going straight through YouTube, except for the webinars, and they'll eventually be doing the very same thing. I'm really happy to have so many of you already subscribed, and so many views have already taken place. We have well over 50,000 views in over a year, and on our YouTube channel alone. And that is amazing considering we're a niche. So I know you're needing all that we're offering, and that's why we're here. And I hope you'll continue to share with others and help them to be a part of this, because we want to help as many people as we can. So again, please subscribe to the YouTube channel. It's really vital for you to do so, and it doesn't cost anything to do it. We're going to go ahead and get started. And our first episode for this year, Dean Tong is our guest in this episode. He actually is working for 27 years now with some very high conflict cases with child abuse, as far as sexual abuse, with people that have been accused of this. And he's going to share some important information with you. So many people can be falsely accused, but yet still there's many that are accused that are guilty. So he's going to explain all this to you in this episode. Before we begin with that, we're going to share some messages with you, and we look forward to you being with us in this coming year. Thank you.
Divorce and co-parenting are a major life interruption for families, especially the kids, but also for parents and grandparents. And it's even worse in blame-filled, high-conflict cases. When parents engage in alienation by turning the kids against the other parent or grandparents, kids suffer. They're denied the opportunity to build the 4 big skills necessary for future resilience. New Ways for Families online class can help. Parents learn to use our popular BIF and EAR skills to calm the conflict and stop the hostile emails and texts. And we even have a class for kids and parents to learn together. Research shows a 75% improvement in joint parental decision-making after this course is taken, plus overall improvements for kids' well-being. Don't wait to make this affordable investment in your children's future and improve your well-being too. Start learning new ways for your family today at conflictplaybook.com.
Hello, I'm Edward Crook, and I'm pleased to be the keynote speaker for the 2023 Family Access International Conference under the theme Alienation, the Truth behind the trauma and abuse of alienation. And the title of my presentation, which is The Trauma of Parental Alienation as a Form of Family Violence and Child Abuse, is directly in line with the theme of the conference. And I'm very happy about that, because at the center of both my practice as a social worker and also as a family mediator And at the core of my teaching and my research over the last 30 years or so, which has been all in the realm of children and families, is a focus on attachment and loss. I've really been honed in on the experiences of parents and children who are forcibly separated from each other. And I've always adopted from the beginning, over the last 30 years, it's always been at the center of my practice, is a trauma-informed approach. So the interventions that I utilize in practice and the practices that I teach in social work and family mediation are very much trauma-informed. What is unique about parental alienation, that it's a kind of a unique form of trauma, a unique form of complex trauma on many levels. First of all, it affects both targeted parents and their children in parallel. And practitioners in the field are really challenged in regard to intervention that is directed at both child and parent. Secondly, it's an unresolved form of trauma and of abuse. It's ongoing. It remains unresolved. I noted that from the beginning of my research with traumatized parents and their children. It seems to never, that there's a full-scale grieving process, a full-scale trauma going on, but it's ongoing and it's never really resolved in many cases. People get stuck at different sort of points of the bereavement and attachment and loss continuum. And thus it presents challenges. It's an immediate kind of urgent crisis for people. It doesn't seem to get better with time, the trauma. Thirdly, it's both a form of individual abuse and collective abuse. That really makes it very complex and requiring a multifaceted approach, not just at the individual level, but at the sort of systems level. There's both an individual perpetrator involved in the abuse, but it's also a collective form of abuse in which social institutions such as the legal system, the child welfare system, the courts, it's both, individual and collective abuse, in that it seems that we're working with a system that's invested in maintaining the status quo and doesn't really deal with parental alienation all that effectively. Now, what you'll get from me in my presentation will be, I guess, a more radical view of reform that's necessary. I'm going to focus also on diagnosis and assessment of parental alienation. It's really not that hard to diagnose violence and abuse and trauma and alienation. So why do we keep getting stuck in that regard? I'm really going to kind of focus on a practical approach to the reduction of harm and elimination of parental alienation. But my focus is mainly going to be on systemic change and the need for that, and how everyone has a responsibility toward addressing the alienation. It seems that the system, so-called the system that so many parents talk about, seems almost tailor-made to not only perpetuate parental alienation, but to create it, to cause it, in that it polarizes parents. There's sometimes potential for healing and reconciliation in the sense of not kind of cutting someone out of the picture in a child's life. This primal wound that is parental alienation can be prevented through systemic reform, removing those who profit from the adversarial system just right out of the picture. At the very least, you'll find my perspective to be thought-provoking, and the ideas that it stimulates will challenge these so-called received ideas, ideas that you've received over the years. And I'm looking forward to challenges, questions, debate, discussion, whether you're a parent, a politician, a policymaker, or a family practitioner in the legal or mental health fields. We all have a role to play in ameliorating reducing harms, ameliorating alienation, and eliminating alienation. We're all responsible. I look forward to the conference, and thank you for your time today.
Good afternoon, Dean Tong here on behalf of Families Divided TV. And I thank you all for having me today to try to give you a little rundown and education and feedback on the issue of false abuse allegations, child abuse allegations, domestic violence allegations with respect to what we know as parental alienation, this emotional, mental, psychological form of child abuse. Many people out there on Facebook and out there in the real world who don't get involved professionally in these cases like I do think that most of these allegations, are false when they are proven to be false. But in reality, most cases are not false. So we have to go through the definitional, meaning of false and what that means, which is basically made in bad faith or premeditation with malice aforethought, where somebody's out to hurt you, perhaps call the abuse hotline number on you to ruin your life, perhaps send you to jail, separate you from your kids. Most of these cases are not false. Only about 5% of cases, 1 in 20, are actually false. Most cases are mistakes, errors by the system that's investigating, CPS, the police, perhaps the child forensic interviewer is interviewing the child at the Child Advocacy Center, or perhaps a child might have said you sexually abused her or physically abused her, and maybe it happened, but they got the wrong guy, mistaken identity. I get involved in cases, a lot of cases where there are high conflict, divorce, parenting time disputes, and child custody battles. Certainly there's a possible motive, a means, method, and opportunity for the parent behind a accusing child to wrongly accuse the other parent, to gain equity at law in court, to wield that child as a pawn, weapon, or tool to do so. And of course, these are the 911 cases, if you will, of parental alienation, because they are the ones that will automatically raise the eyebrows of the trier of fact, the judge, who has to rule in the child's best interest, not the litigant's best interest, not the parent's best interest, and perhaps will make a mistake on the side of that child, on the side of caution, which means he could believe the allegation or she could believe the allegation. So most of these cases are mistakes, errors. We get what's called linguistic or language errors from children and by children. I had a case consult where a little girl, 4 years old, said that daddy put his pee-pee on her pee-pee. Of course, the accused was arrested, facing 25 years to life imprisonment down here in Florida. This was 20 years ago when I got the call. But fortunately, we were able to get Dr. Ann Graff from Walker involved. She is now deceased, but she was the leading forensic linguist in America at the time. And she determined that what the child meant was that the father urinated on the child's urine in the commode that she forgot to flush. So hence pee-pee on pee-pee was a language mistake, error, ill-perceived by the system. So this is a well-meaning, well-intentioned, but perhaps sometimes misguided system that rushes to judgment in these cases. This is the system that's charged by the legislature to protect kids at risk and harm's way and jeopardy. And certainly, they can go by what a child says and support those allegations based on hearsay. Hearsay by definition is an out-of-court statement made for the truth of the matter asserted. And while it's usually Rule 803 in all 50 states that pertains to this exception of the hearsay rule, where you could wind up getting arrested, lose your parental rights over what a child says that you did to her or him, there are factors that govern the admissibility of hearsay in a court of law. Those factors are that the child's allegation has to be made spontaneously or contemporaneously, with an indicia of reliability and an inherent degree of trustworthiness. And certainly the best evidence that comes from the hearsay allegation of any child, whether it's physical abuse, sexual abuse, would be that child forensic interview conducted on, captured on DVD at the Child Advocacy Center of that child. So for a 4 or 5-year-old, that interview may last 20 or 30 minutes at the most. For older children, it can last up to an hour or even longer. And the interviewer will go over rapport, build rapport with the child to get the child comfortable. We'll go over right from wrong, truth from lie, good touch from bad touch, from secret touch, and do a touch inquiry with the child. We'll go over the body parts. And of course, if it's physical or sexual abuse allegations where there's no medical or forensic proof, which usually there is not, then the interviewer will get into the index allegations, perhaps the report that she's received from Child Protective Services on why the child's there to talk to that interviewer in the first place. But the interviewer could use a semi-structured methodology, which employs leading, suggestive, direct, repeated, and or forced choice questions, questions that could contaminate the child's information. So as I said, the child's information has to be made spontaneously. That's from the child's implicit or unconscious memory. So it's the same memory as the child getting up in the morning, basically putting water on his or her face, taking a shower, combing his or her hair, and putting her dress on, or his jeans on, or his suit on. Little kids don't wear suits, but so the point is, you don't have to think about this. This is your unconscious memory. It's spontaneous. It's when it's the explicit memory and the memory that can produce contamination, can cause schemas. Schemas are enzymes or proteins that can modify or alter one's memory. This is where the child can be in error and make a mistake, and the interviewer can assist that mistake. Okay, so the information has to be of the child's own free volition concerning a traumatic incident. And so we talk about parental alienation. We talk about this emotional, mental, psychological form of child abuse. And basically, the allegation of abuse, whether it's sexual or physical, is the one allegation, the one issue that a judge is going to make an immediate ruling on, and most likely will, like I said earlier, err on the side of the child against the accused. And now the accused is presumed guilty. The accused is left having to try to prove a negative to prove his or her innocence. On sexual abuse allegations, most of these allegations are lodged against men and fathers. In reality, most of the abuse that happens in these cases is perpetrated by stepfathers or boyfriends, paramours, not the natural father. But I get a lot of cases where the natural biological father is the accused. I've even had cases where the natural father has been accused of molesting both genders, both male and female children, even though the empirical raw test data and studies and research points to the fact that it's usually one gender or the other gender that the father would be perpetrating molest against. So in these cases, because there's so much hanging in the balance, as I say, you can be arrested just on the hearsay word of a child, being the exception to the hearsay rule. You can face a dependency petition in juvenile court filed by Child Protective Services against you. You can wind up on the Child Abuse Registry blacklist of suspected abusers for that state that you are accused in. And then you'll have to get an attorney to file a request for administrative appeals hearing to litigate the same. Again, proving your innocence, proving that negative at that hearing, to try to contest the CPS agency that you shouldn't be on that blacklist, because if you're a teacher, if you're a nurse, if you're a youth care worker, it's going to kill your occupation unless you get that finding redacted by an administrative law judge at an administrative appeals hearing. So in North Carolina, that would be the RIL, or responsible individual list, that they can put you on. So it's very important that you do contest that finding go to hearing, litigate that with an attorney, perhaps an expert, and try to induce the administrative law judge to redact that finding back from indicated or substantiated or confirmed back to unsubstantiated or unfounded. Obviously, as I alluded to, you can be arrested, facing prison time, sex offender registration, if it's a sexual abuse allegation. And obviously in juvenile dependency court, termination of parental rights becomes a possible issue if a judge adjudicates the child dependent, meaning the child has been abused, neglected, or abandoned by law. And then so CPS will then give the accused a case plan, hoops to jump through. If the accused does not substantially comply with that case plan over a 1-year time frame, the state can then file a petition for termination of parental rights. And then you have to go to a hearing where the state has to prove their burden of proof by clear and convincing evidence. If you lose that, you have a right to appeal. But your appellate remedy is basically on a twofold basis. You file a direct appeal, and if you lose that based on abuses of discretion by the trial court, you would have one more legal remedy, and that would be for IAC, ineffective assistance of counsel, that the attorney was not effective in assisting you, the accused, the client, at the appellate, at the termination of parental rights hearing or trial. And therefore, you're asking the court to reverse and remand the decision of the judge. So obviously with an appellate court, you're going before 3 judges, not 1 judge, to reverse and remand that back for further proceedings back in front of a trial court to get another shot at it, another bite at that legal apple, to give you your right to due process. Perhaps you didn't have an expert at your first trial, and that's what you're asking the appellate court to do. So please, I'm not a lawyer. I'm a forensic trial consultant and subject matter expert on the issue of unfounded and false child abuse allegations nationally. And so I cannot give you legal advice. So anything I say during this webinar, please back it up by calling an attorney who's licensed to practice law in your state on these issues. Speaking of attorneys, since I work with attorneys for a living in working these cases, and I have worked cases in all 50 states, and I've testified as an expert in 16 states in multiple areas of psychology and social science, there is a formula for choosing your attorney. I am also a published author of 3 books. In my last book, which was published 20 years ago, Elusive Innocence, Survival Guide for the Falsely Accused, you will find a section, How to Choose Your Attorney, at my website, abuse-excuse.com, which has been up on the internet for 25 years, since 1997. You will also find a section by the same title, How to Choose Your Attorney. There is an art and a science to picking the right lawyer, and it does not mean throwing darts at the dartboard. Okay. Your lawyer is going to be your quarterback. Your lawyer is responsible for the control of the litigation in your case. Your lawyer is your shot caller. So think of the attorney as the quarterback. If you retain my services as an expert, think of me as a running back. While I may help to score the touchdown, your attorney controls the litigation, as I said. I can only suggest and recommend things to be done by the attorney. The attorney can ignore my requests, but I cannot compel the attorney to do anything. That is up to the client, the accused, meaning you. If you're involved in any case in juvenile court, family court, criminal court, appellate court, administrative court, where you might have to request an administrative appeals hearing to litigate against your name being put on the state child abuse registry. So it's very important that you choose the right attorney. You want a lawyer, obviously, who's board certified in family law, AV rated in Martindale-Hubbell. You want a lawyer who has a lot of experience in this type of litigation. And you want to check out that lawyer's AVO reviews. That's avvo.com. Avvo.com is the top legal review website. And you might even want to talk to some attorneys as a peer review recommendation for the lawyer that you're potentially thinking of hiring to help you in a case. Lawyers will not give you their client base. I do, but lawyers will not. And certainly that is privileged. But you do have to know that the attorney has had success. For example, if you've been arrested, you're facing criminal charges, perhaps life imprisonment for sexual abuse of a child that you did not commit. Does your lawyer have not guilty verdicts under his or her belt? Has he or she achieved not guilty verdicts? Has he or she achieved hung juries and mistrials based on the same? Has he or she achieved null prosecutions, where the state declines to prosecute it before it goes to trial? Or, for example, in my state of Florida, a JOA, judgment on acquittal. So it's very important before you ink a retainer agreement with a lawyer, before you plunk down a high retainer fee, which I can tell you for a criminal child sex abuse case, you're looking at about $25,000 or more for counsel. It could be the most important decision you're going to make in your entire life. And certainly I work with lawyers of all kinds, all across America. I've worked with some fantastic lawyers. I've worked with some that are not so fantastic, but I have worked and achieved fantastic results with lawyers who are even public defenders and court-appointed lawyers. So, I'm a guy who I'm just here as a tool to help the attorney, to help clear your name, the accused, and get you your kids back. If it's a custody battle with no allegations, if it's a custody battle with allegations, whatever the case may be, I'm here to help as a tool. You're a lawyer. I help fashion the questions for depositions of opposing fact and expert witnesses. I help at hearings. I help at trials. And certainly I also am looking at the documents like your lawyer does. And I may see stuff and things that are unimportant to the lawyer, but are important to me. I may see things that your lawyer misses because your attorney's so busy with other cases and having to go to court all the time. So, that's just the nature of the beast in these cases. I get some cases that are north of 5,000 pages. I've had a few that are 10,000 pages. I mean, just boxes and boxes and boxes of court documents. Some cases I have 20 to 30 DVDs of child forensic interviews on children allegedly abused in cases. So it's very labor and time intensive, both for me as an expert, for the attorney who's your litigator. Be very careful in these cases. If you are in a high conflict case, you do not want a mediator, okay? You don't want a lawyer who only does collaborative law or conciliation or, but just is not a litigator, does not get involved in high conflict, protracted litigation cases. You need a litigator, a trial attorney, who's an expert in trial litigation. And then, if it's possible to get a settlement down the line, that litigator can achieve both jobs of litigating the case to victory for you, getting you joint custody, sole legal custody on the health, education, welfare decisions of the child, physical custody of the child, whatever your goal is, but can also sign off on an out-of-court settlement agreement with the opposing party if that comes to be and pass on the table as well. Now, in cases of mine, I get involved a lot in cases of young children, cases where kids can be very suggestible and impressionable. If they can talk about the Tooth Fairy, Santa Claus, Peter Pan, or the Easter Bunny, they can talk about how Daddy touched my pee-pee. I already mentioned the one linguistic error case that I was consulted on 20 years ago, where the child said, Daddy put his pee-pee on her pee-pee. And it was not genital on genital contact. That's not what she meant. So you can obtain, in these cases, many source misattribution errors, meaning there's another reason or hypothesis for why the child is saying what he or she is saying. Okay. Children don't have the same brain formation as adults do, like we do. Okay, so their amygdala, their hippocampus, versus their prefrontal cortex will not be as developed as ours. And certainly their language will be limited. And so it's very important to have any child who's forensically interviewed by the government for that interview to be critiqued by a professional, whether it's myself, who's nationally certified as a child forensic interviewer, or whether it's a psychologist or psychiatrist. You do want that interview reviewed by a professional, and to see, how many, if any, leading, suggestive, direct, which are closed-ended questions, repeated questions, forced choice questions, questions that employ what's called negative stereotype induction, which is basically vilifying the accused in the question. You want to see how many of those questions were asked by the interviewer of the child, which could taint or adulterate the child's information. Okay, so the interviewer should not be putting words or thoughts or ideas into the child's mind. This violates the science of suggestibility, and it can contaminate the kid's information, therefore rendering the kid's information unreliable and untrustworthy. Okay, so the science, the rule of law, rather, that governs the admissibility of science and expert testimony in a court of law in most states is called Daubert, D-A-U-B-E-R-T, and in some states left in America, it's called Frye, F-R-Y-E. Daubert is the more stringent test than Frye. Frye basically says that the scientific theory, such as parental alienation, has to be recognized and accepted by the entire general psychological community. Well, I think we would all agree that pretty much all judges now, all CPS agencies, all experts, all child forensic interviewers and therapists have all heard, for the most part, this insidious form of child abuse called parental alienation, basically estrangement of the child by an opposing parent. Now, it can be a protective parent and not maliciously alienating the child against the other parent, the targeted parent. Okay, so there can be unwitting alienation. There can be coaching that's malicious, and there can be unwitting or naive coaching. Again, the child could hear within an earshot of what a mother is saying in the home, which is derogatory of the opposing parent, the father. And then the child goes back to the father and says, Daddy, Mommy called you a jerk. Okay, and that may or may not be reduced to writing in your Our Family Wizard app close or Talking Parents app, or text message or email or post on at social media on Facebook or whatever. And that's where you need the information, because that's admissible evidence in court. Obviously, something over the phone is not going to help you. So you do need to document all information that is reduced to writing for your attorney, so that it can be used as exhibit evidence in court at a hearing to get you equity at law in court and relief. These cases are very high conflict. They bring out the worst in families. You're going to hear about reunification therapy. To me, that's kind of an overblown theory, because if a child has a fixed and rigid belief system that you molested her or him, and of course there's a parent over that child who believes the same, there could be a F24 in the ICD-11 induced delusional disorder that exists that's been undiagnosed. Okay, so we may have a fixed and rigid and possibly false belief system shared by both the alienated parent and the child victim, who's accusing the targeted parent. But the system isn't looking at false beliefs, and certainly a therapeutic remedy might be what's called schema therapy. And so you will get a Wikipedia page on schema therapy on the internet under Google. And basically what this tries to do is reformat or restructure the thinking pattern of the child. And if you are allowed, the targeted parent, that is, by the court, to basically join with the child at a conjoint therapy session, you would want to bring prior photos and videos of your prior relationship with the child that was normal to the therapist at session. And of course, you would want the therapist to be a certified schema therapist to basically try to refocus the thinking of the child. And of course, this is after the court has made a finding of fact, conclusion of law, that the child abuse allegations against the targeted parent, the accused, were unsubstantiated or were false, and therapies to be conducted as part of a reunification process. But reunification therapy by itself, without doing schema therapy, may not be helpful. And so schema therapy is something you want to look at. And finding a schema therapist may be like finding a needle in a haystack, but you got to keep searching. And there may be one or two or three in your state you can try out at. Go look at psychologytoday.com, choose your state from the drop-down box, and look for certified schema therapists. Psychological evaluations are part of this process in proving a negative, your innocence in court. So for me, for decades now, I've been having clients of mine get tested to basically show that they possess no sexual interest or arousal in prepubescent children. If it's a 5-year-old little girl, prepubescent female children. And if the child said that Daddy told me to keep this a secret, we're also looking for the cognitive distortion scale score as part of the ABLE screen test. There's also another test called the multidimensional inventory for development, sex, and aggression that has a cognitive distortion scale score within the same. So we're looking for convergent validity of cognitive distortion scale scores. Less than 25% would be a score we're hopeful to get for an accused that's not trying to justify his actual abuse. Okay, so an accused who may score 50, 60, 70% on the cognitive distortion scale score may be somebody who's a con man who's trying to pull the wool over everybody's eyes in the case and is trying to beat the rap. So we'll know from the empirical raw test data. Our gold standard child sex test, if you will, is called the ABLE assessment for sexual interest. I have a published paper on this from 15 years ago in 2007. The website is ABLE Screening, that's ABEL screening.com. This test is 1/2 laptop computer, which assesses and gauges the accused sexual interest level from consensual sexual relations with adult women, perhaps, versus sexual arousal or interest in children and prepubescent children. Most of my cases are prepubescent. I do get cases that are post-pubescent, and even those kids can be suggestible as well. We have some studies on that as well called developmental reversals of false memories. So I think the testing with a doctor who can bolster the credibility of the accused, especially in a criminal case, can be very important as another piece of ammunition or evidence for the attorney to use in impeaching the credibility of an allegation against the accused by a child. And certainly, if the child is being coached, I usually pick up on that on the DVD interview of the child at the child forensic interview. But oftentimes the interviewer, again, well-meaning, well-intentioned, but perhaps misguided, doesn't even screen that child for possible coaching, such as asking the child, did anybody tell you what to tell me today? And then, of course, the proper way to interview the kid, the child interviewee, child victim, because of course we have non-abused child victims as well as truly abused child victims. They're both victims. The proper way to interview the child via the NICHD method, which is the method I profess to be used across America, that is our evidence-based best practice method, is to ask the child first out of the gate, can you tell me what happened? So that's asking for contextual details from the child's reconstructive memory, not reproductive memory. Okay, memory that can be contaminated by the interviewer. You do not want to ask the child, did daddy touch your pee-pee? Okay, you're putting words and thoughts and ideas and verbs, touch and daddy into the child's mind. You're not letting the child make a spontaneous contemporaneous allegation. The case law requires that the child make a spontaneous allegation, outcry, disclosure that is both reliable and trustworthy in order for the same to be deemed credible by a court of law, a jury in a criminal case. So it's very important. Now, most states don't use the NICHD. Only about 7 jurisdictions in America use the NICHD only. And certainly, that is, I have a problem with that. But the states tend to use a semi-structured methodology, APSAC or RATAC or finding words versus the structured protocol called the National Institute for Child Health and Human Development, also known as the NICHD. I worked many cases with Dr. Phil Esplin, who is retired now and has been for 5 years, but Dr. Esplin was the co-author of the initial NICHD model introduced in 2000. One final issue I'd like to cover real quick is called coercive control as a form of parental alienation. Coercive control, of course, can be an actual form of abuse that is basically perpetrated by a person who is guilty of domestic violence in a situation, and you may have a victim who gravitates to trauma bonding, and that can even exacerbate the situation for the victim. And certainly those cases are actually more the norm. But in cases that that I'm talking about here, for targeted victims of parental alienation, an alienator can forcefully coerce a child to estrange from a targeted parent. That child will lose emotional attachment to the targeted parent. That child will show 100% enmeshment to the alienator. That alienator will not have ambivalence, will not have mixed feelings about anything, or consider alternative hypotheses. And the whole key here is not just for the government who's investigating these abuse allegations, but for the alienators. They have to have alternative hypotheses. You have to think of other possible explanations for why the child is saying what he or she is saying. And oftentimes we get confirmatory bias, preconceived notions by even protective parents who are just thinking because a child is touching his or her crotch area or exhibiting signs or symptoms of behaviors consistent with sexual abuse, that it must be sexual abuse, but it may very well be something else besides. Okay, so you have to consider all situations. You have to actually challenge the child's memory. This is called source monitoring. And so coercive control is now starting to be legislatively adopted in different states. I just had a case recently in Hawaii. I believe it's HRS 586-1 is the statute out there in Hawaii, which memorializes coercive control. And certainly attorneys can use this, in litigating parental alienation. Parental alienation, as most people know, is not published in the DSM-5 or the ICD-11, but it has been accepted by the American Academy of Pediatrics. It has been accepted by the American Academy of Child and Adolescent Psychiatry. Dr. Bernay is trying to get the DSM committee to approve what's called PARP, parental alienation relational problem, to be published in the DSM-5 text revision, the DSM-5 TR. And certainly we hope that transpires. And certainly it has been a challenge to get the American Psychiatric Association to publish the word alienation in its mental health diagnostic Bible. And certainly, we can sometimes get around that because there are subtypes. We have estrangement, we have child psychological abuse, we have child affected by parental relationship distress, we have parent-child relational problem that are published. But the word alienation is not in there. And so it can be frowned upon by critics, who basically believe and think that this is junk science. So I talked about Dauber and Fry. That's what, that's what basically has to be litigated in court to try to get a judge as the gatekeeper of the science to approve the fact that this is not junk science, parental alienation. It is a real science. And of course, the second test is if the court does find it's a science, you have to then draw that nexus and link it to the child has the alienation that has been the child's been a victim of that alienation. Has that child suffered signs, symptoms, behavior, psychosomatic issues, headaches, stomach aches, nausea, vomiting, regressive behaviors, nightmares and flashbacks because of the alienation? If you can show that to a judge, articulate the physical, mental health ramifications, iatrogenic effects from the alienation, you can be successful in getting a judge to adopt the fact that the child is a victim of alienation and cause that material and substantial change of circumstances in a family court where a judge will modify the custody order for the targeted parent. And that's basically all I have to say today. I am thankful for Elaine Cobb and Families Divided TV for having me on today. And if you all have any questions or concerns or comments, please visit me at my website, www.abuse-excuse.com. Thank you.
Next week on Families Divided TV, Chris Turner shares with us common mistakes of target parents in litigation.